ma'am.
Have you discussed this with Mr. Shaw?
I have.
Are you satisfied with his representation of you?
Absolutely.
The charge you're pleading guilty to says that on or about March 1st, 2020, that you unlawfully, knowingly, or recklessly caused bodily injury to Stephen Guerrera. To that count, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Before I can accept the guilty plea, I have to make sure you understand all of your rights and the effects of your guilty plea. And I've been provided with the Rule 11 advisement. Did you review that with Mr. Shaw?
Yes,
And did
ma'am.
he answer any questions you had about it?
Yes, he did.
And Mr. Shaw, that's correct as to that advisement as well as the elements?
Yes, Your Honor.
Mr. Greco, I'm going to go through those rights with you. You have the right to be represented by counsel at all stages of a criminal proceeding, not today's disposition, but any trial as well. If you're determined to be indigent, counsel is appointed to represent you at no cost to you. You have the right to a speedy and public jury trial. At that trial, you would be presumed innocent. The district attorney must prove your guilt by proving all the elements of the charge beyond a reasonable doubt to all 12 members of a jury, because any jury verdict must be unanimous. At trial, you would have various personal rights: the right to testify, the right not to testify, the right to make the choice whether to testify or not, the right to subpoena and call witnesses on your own behalf, to cross-examine and confront witnesses who testified against you, and you would have the right to appeal to a higher court if you were convicted at that trial. Do you understand those rights?
Yes, ma'am.
And do you understand when you plead guilty, you give up all those rights?
Yes, I did.
Now, before you could be found guilty of this charge, the people have to prove its elements beyond a reasonable doubt. And I read the elements to you, and I read the charge, but they're explained in more detail in a written advisement. And Mr. Shaw has confirmed that he's reviewed the written advisement with you and answered any questions you had about the elements. Is that correct, Mr. Greco?
Yes, ma'am.
Do you understand the elements of third-degree assault?
I do.
And do you understand when you plead guilty, you admit those elements and give up any defense you may have?
Yes, ma'am.
You're pleading guilty to a Class 1 misdemeanor, carries a sentence of between 6 months and 24 months in the Denver County Jail, and a fine of up to $5,000. Do you understand the possible penalties?
Yes, ma'am.
Are there any promises that have been made to get you to plead guilty other than the promises told to me in court today?
No, Your Honor.
Is anyone forcing you to plead guilty?
No.
Is the decision to plead guilty your own free and voluntary decision?
Yes, ma'am.
And is there a factual basis, Mr. Shaw?
Your Honor, we would waive establishment of a factual basis.
Do you have any questions about your guilty plea, Mr. Greco?
No, ma'am.
Do you still want to plead guilty?
Yes.
Court will note that there is a Rule 5 advisement: accept the plea, make written findings regarding acceptance of the plea. Judgment of conviction enters on count 2. Count 1 is dismissed. And do both sides waive a pre-sentence report?
Yes, Your Honor. Yes, Your Honor.
Okay, and Mr. Hoffman, on behalf of the people?
Your Honor, we are in VRA compliance for this plea agreement. We do not have any restitution at this time.
And Mr. Shaw?
Your Honor, we just asked the court go along with the proposed disposition. Mr. Greco is 44. He has very little criminal history. He has a DUI from back in his teenage years, and that's about it. He is an electrician, but work has been slow during the pandemic and difficult for him. So we would ask that the court consider waiving what fees and costs it can. Mr. Greco understands that his behavior here was out of line and is ready to take responsibility for it and move forward with his life.
And Mr. Greco, anything you want to tell me?
No, ma'am. Evan has pretty much summed it up.
Okay. Mr. Greco, I am going to approve the disposition. I will place you on probation for 2 years. You're ordered to comply with any terms and conditions deemed appropriate by the probation department. Since we don't have a pre-sentence report, I don't know what those programs should be, so I will have probation do an assessment and set forth the conditions. I'll find that there's no restitution, and I will otherwise because of the current financial conditions, with any fees, costs, and surcharges that can report. Call probation today to begin your supervision. And has Mr. Shaw given you that phone number, or do you need me to give it to you?
I'm sure Evan can give it to me.
Okay.
That's good. I have not provided it to him yet, but I can do so right now.
Okay,
I'm
so Mr. Greco, I'll have you call probation today, okay?
Yes, ma'am.
Okay, good luck to you, sir.
Thank you so much.
Okay.
Thank you.
And I have a question. Do we have somebody from the Department of Corrections there? There's someone I can't identify in custody. And we have 830 writ for DOC.
Is that Mr. Aguilar?
Yes, ma'am, we're here.
Okay, are you ready in that case, or do you need a breakout room, Ms. White?
Judge, I will need a breakout. Could we briefly, before that, just call Ms. Macias Williams? She is also on the screen, and then I'll do a breakout with Mr. Aguilar. Macias Williams is number 35.
Okay, then the court will call number 35, which is 20 CR 5858, Macias Williams.
Andrew Luxon for the people.
Ashley White from the Public Defender's Office on behalf of Ms. Macias Williams, who appears via video.
And Ms. Macias Williams, you have the right to appear in person with Ms. White. Today, are you giving up that right and agreeing to appear by audio video conferencing?
No, they never let us come in person anyway, so I guess I have to agree to it, correct?
Well, you can come in person. We are trying to be as safe as possible right now.
Well, I'd rather come in person, but you know, you guys make the rules, we just follow them, so.
So, it sounds like you don't want to give up your right to appear in person.
I'm okay today, but next time I come to court, I definitely want to be there in person, you know?
Okay.
And just Ms. Macias Williams, we were going to set over for next week, but if you are requesting to be in person, we will not be able to have court next week. I'll have to clear a date for someone else to appear with you, and it will not be me that appears with you in person in court. Are you okay with that?
The only problem with this is that I haven't had a chance to meet with my attorney. She told me something about a sentence, and I tried to agree to it at the end of it after I had calmed down. And now she wants to push it out for another week because she feels like she hasn't had adequate time to advise me of my right, and she doesn't feel comfortable. But I feel comfortable agreeing to it. She don't feel comfortable agreeing to it.
And so, Judge, I am in court. So I was going to ask the court to set this over for next week. I have concerns. I think that I need to make sure Ms. Macias Williams understands fully the plea agreement, and I need to be able to review paperwork with her. It is not her fault that hasn't happened yet. I have had her on my jail list for the past 2 weeks. I also had her on my jail list for 2 weeks before her preliminary hearing. I've received 0 calls on despite my repeated requests. And so I understand it's not her fault. I explained that to her, but I do not think that we can go forward with the plea agreement today because I have not been able to fully advise her, and I don't think she fully understands. It's a plea agreement that calls for a stipulation to community corrections, but if not accepted, then there are other sort of conditions that fall into place, and I need to make sure she understands that. My plan was to ask the court to set this next week on an off docket day, but if Ms. Macias Williams is requesting an in-person hearing, then that will not be possible, and I will have to wait to make sure I can quiz with someone else who could appear with her. The court knows I have my own health reasons going on, so I will not be appearing.
So
I'm okay with that. If I can get it early in the week, the better. You know, I definitely deserve that because I have attempted to call her on Wednesdays and Thursdays is the days that she told me she'd be in the office, and I'm on 20. This is my problem, Your Honor. Is here in Denver City and County, wherever I'm at. I have 23 and 1, okay? So there's some days that I don't get out for my pod time until 6 p.m. So
Okay.
I'm gonna call my attorney, even though she literally is always in her office on Wednesdays and Thursdays. It's not her fault that it's after office hours that I'm being released for myself. But here in the county, I'm on 23 and 1, so actually she answered her phone when I called her. But I couldn't call her for the last 2 weeks because I've been getting let out at 7 a.m. or 6 p.m. Do you understand, Your Honor? So it's not Ashley's fault. It's not my fault. It's the county's fault because they won't let me go to an open pot. They have me on 23 and 1s. I've been here for 60 days, Your Honor, and I
Ms.
really
Macias,
need
I get the picture. I'm understanding. Things are extraordinarily complicated for right now. Yes, I can set this on Monday if you want it.
Thank you.
On Monday.
Well, and Judge, here's my concern if we said Monday. I
I'll
don't
give you a
really have
breakout
faith.
room.
Okay,
give you a break.
perfect.
I will
Perfect.
give you as long as you need to be in a breakout room.
That's perfect. Thank you.
Okay, so we'll see you on Monday, Ms. Macias Williams, and I'm going to arrange it so you can have while we're calling other cases. My clerk's concerned on Monday because she's in custody because of the other dockets. It interferes with other dockets. What about Tuesday?
That's fine too.
So excellent. So Tuesday, it's 8:30, and then we have a small docket, so you'll have time to talk to Miss. Okay.
Okay, thank you. Sorry, Ashley.
We'll appear together on Tuesday. It will be virtual again, but you and I will have a separate video breakout room so we can talk. Okay.
Thank you. I appreciate both these. Thank
Okay.
you, Your Honor.
Okay,
Thank you,
then we're
Ashley.
going to put you in a breakout room, Ms. White, with Mr. Eckler, number
Yes.
1.
Okay.
Okay.
So that's
and
it,
then-
Angelica. I'll see you Tuesday.
Okay, thank you.
Okay, so, and while that's happening, I'm going to identify some call-in users. I have 3036, last 2 digits 10. Whose number is that, please?
I'm just waiting for Jackson Reynolds.
Is this Mr. Hagan?
Yes,
Okay, then we can call, assuming Mr. Weber's still with us.
I am, Your Honor.
So we have Mr. Jackson Reynolds. We'll call that case. That's number,
I think it's 51, 52, 53.
okay, those cases are 20CR1989, 20CR2651, and 20CR4860. Jackson Reynolds.
Drew Luxon, Brenna Zortman on behalf of the people.
Lyndon Hagan's on 1989 and 2651.
And Nicholas Weber, Offset Public Defender on 20 CR 4860. Your Honor, we're set for sentencing.
And Mr. Reynolds, can you hear everyone?
Yes, Your Honor.
And Mr. Reynolds, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio video conferencing?
Yes, Your Honor.
Are you doing that voluntarily, meaning of your own free will?
Yes, Your Honor.
Okay, and the matters are set for sentencing. Are both sides ready to proceed?
Yes.
Yes, Your Honor.
Okay, and I'll start with the people's position.
Ms. Zortman, do you have any comments?
I do not.
Your Honor, the ASR there, as the court saw, was completed, and it's my understanding that Mr. Reynolds here is a suitable candidate for the Veterans Court Program. I think that, as we discussed at the Providency hearing, the hard work of Mr. Weber and Mr. Hagan's here to get Mr. Reynolds in this program, or to be considered for this program, has paid off to his benefit. You know, his history in these cases here are no small matters, but hopefully the structure and the resources that the Veterans Court has at its disposal are things he'll take advantage of, and we won't be in a situation where he finds himself in the Department of Corrections. So I would ask the court to sentence him to Veterans Court.
And is there any restitution in any of the 3 cases?
That's a good question. It is going to take me just a second to get through them all. I don't know if the court would like to hear from defense.
There is not in 2651. There's no restitution.
Okay, and on behalf of Mr. Reynolds,
Your
either
Honor,
Mr. or both?
Defense echoes the request for Veterans Court. I know that Mr. Reynolds has done a lot of work himself, and I've been in communication with both his case manager and his representative at the VA. They have housing ready and standing by. They were waiting to see, obviously, what happened with sentencing today, but he does have stable housing set up. I think it sounds like it's going to be somewhat temporary for about a week until it's an actual bed in either Harbor Lights or a similar inpatient facility. So he's all set up with that, and as soon as we're done here, I will email both of those individuals and let them know what the court's decision is. I'm asking for the court to impose probation, and then if he could be released today or tomorrow, so that I can let staff over there know when he's going to be released for probation.
He has warrants in El Paso.
And he knows about those. I don't know, and he's already set up to do a virtual writ in El Paso. I think in late January, he and I were talking about that. I don't know that they're going to come get him if the court were to release him today. I know that at least I speak to El Paso County. I know Arapahoe is not coming to get people right now.
And Mr. Reynolds, Mr. Higgins, did you want to add
I really
anything?
don't. I think he knows. I talked to him this morning, and he knows this is a really, really good chance for him to make it. He's got so much support out there, and he's been in for a while, and I think he's pretty clean. But he also knows that if he doesn't do well, this is pretty much where it'll stop. So I think we're all grateful for the chance to have him go to Veterans Court and see if he can do it.
And anything you want to tell
No, Your Honor, other than the fact of I have tried to reach out to El Paso County. I don't believe that they are going to come get me. But Miss April Odell, the case worker here, she said that the warrants, she called down there and they said that the warrants were closed. So I don't know what that means exactly, but...
No, the warrants are still active, and there's a virtual hearing set for January 21st on at least one of the cases. Okay. Anything further, Mr. Reynolds?
No.
Okay, the court also agrees that Veterans Court is appropriate, and I did communicate with Magistrate Boyette yesterday and advised him that I'm going to have actually Mr. Reynolds remain in custody till Monday the 14th when he appears in front of Magistrate Boyette. And the reason is because I want to make sure that housing is secure, but there's also that problem lurking in El Paso County. I did alert Judge Groves, the judge in El Paso County, of what was happening here, and advising her that he may appear before the 21st if El Paso exercises those writs. But I want him in front of Judge Boyette before he, just in case El Paso picks him up, so he can be advised of and get set up in veteran court. So the court in all three cases will place them on 2 years probation. All will run concurrent, and that'll be supervised by the Veterans Court. The matter is set for hearing in front of Magistrate Boyette on the 14th at 1:30. And it's already been scheduled, and at that time, Magistrate Boyette will verify the housing and set forth any further conditions. Just in case, Mr. Reynolds gets picked up earlier. I don't know if you can get him heard in El Paso County before next Monday, so he can be released on Monday if Judge Boyette approves it. The court will otherwise waive all fees, costs, and surcharges that are waivable. There is no restitution in the 2651 case. Is there any restitution in the other cases?
I would ask to reserve on 4860 for an appropriate amount of time. No restitution on 1989.
So 1989, no restitution. The court will grant the people 49 days to file a restitution request in 4860. If with a conferral paragraph none is filed, the court will find no pecuniary loss. So, yes, Mr. Reynolds?
Can I ask a quick question? You said you reached out to Judge Gross. Did you hear anything back or no?
No, she just acknowledged that she received my email as to what's happening. I just want to make sure she was informed that you may be there before the 21st.
Okay.
Okay?
Okay.
Okay. Good luck to you, Mr. Reynolds, and I hope you take advantage of the program.
I have two quick custody ones.
Okay?
Number 39, Frank Mendoza.
Mr. Reynolds, I'll let Nathan Buton and April Odell know what's going on.
Okay, number 39 is 20 CR 3490, People versus Frank Mendoza.
Molly Schultz for the people.
John Whitley with the Public Defender's Office on behalf of Mr. Mendoza, who's calling in. The last two numbers of his phone are 49.
Okay, Mr. Mendoza, can you hear me?
Yes, ma'am.
And Mr. Mendoza, you have the right to appear in person with your attorney. Today, are you getting up that right, agreeing to appear by audio conferencing?
Yes, Your Honor.
Are you doing that voluntarily, meaning of your own free will?
Yes, ma'am.
Okay, thank you. And the status?
I got it. This time we would waive any further reading advisement on the complaint. Enter not guilty, please. Separate mandatory disposition and a motion state.
Okay, the court will accept the not guilty plea. Both sides will have 28 days to file motions. We'll set this for a Thursday disposition and Friday motions. And do you want to do the 21st and 22nd again?
That's fine.
And Ms. Schultz?
That's fine as long as the 22nd in the morning.
Okay. January 21st at 8:30 for disposition, January 22nd at 8:30 for motions. Bond is continued till that date and time.
And I've got, thank you, Mr. Mendoza. I've got number 55, Emerson Spiller.
You didn't ask about
Okay, number 55 is 20 CR 284, People versus
Kathy
Spiller.
James to the people.
John Whitley with the Public Defender's Office on behalf of Mr. Spiller, who appears out of custody.
And Mr. Spiller, can you hear everyone? Mr. Spiller? And
yes, can you hear me now?
yes. And Mr. Spiller, you have the right to appear in person with your attorney today. Are you giving up that right and agreeing to appear by audio conferencing?
I am.
Are you doing that voluntarily, meaning of your own free will?
Yes.
1 minute, off the record. Taylor, if you can help with the breakout session, Ms. White needs some help there. Okay, I'm back on the record in Mr. Spiller's case. Matter set for disposition today, motions tomorrow. There are no motions, so can we vacate tomorrow's hearing?
Yes, Your Honor.
And is there a disposition?
Need to get bail dates.
Okay. And how many days will you require for trial?
I'll leave it to Mr. James, probably 3.
That was what I was going to suggest as well. I think 3 days is appropriate. Maybe 3 days should be enough.
And so speedy trial is April 29th. March 15th.
And if I can just, Ms. Grismer's going to be doing this trial with me, so I know she emailed me dates that don't work. I've already got Robert Lucero on March 15th.
I think it's safe to set this against that because I have it also, and I suspect this.
It's the case that I can accept that, as can Ms. Grismer.
March 15th for a 3-day trial. And then we'll set a pre pretrial conference. March 4th for pretrial conference.
That works for defense.
That works for the people.
Okay. Anything further?
Not from the people this time.
Nothing on this case.
Okay, then bond continued.
And Your Honor, I apologize if we could recall Mr. Mendoza. There was an issue I forgot to bring up.
Okay, we'll recall the Mendoza case, which is number 3920 CR 3490.
Molly Schultz for the people.
John Whitley with the Public Defender's Office on behalf of Mr. Mendoza, who appears out of custody, calling in the last two digits of his number 49. I believe he's still there. If not, I thought he was still there. Mr. Mendoza, are you still there? And sorry, Judge, I thought I had seen those numbers go up.
I don't see him.
Okay, I'll get in touch with him and then we can recall this.
Your Honor, I can call it in custody matter.
Yes.
Chapman is David Chapman, number 6.
Okay, number 6 is 20 CR 2690, People versus David Chapman.
Molly Schultz for the people.
Nicholas Weber, also public defender on behalf with Mr. Chapman, who appears by video. We consent to video appearance today.
Hey, Mr. Chapman, can you hear me?
Yes, ma'am.
Hey, Mr. Chapman, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio video conferencing? Are you doing that voluntarily, meaning of your own free will?
Yes.
Okay, and the matter is set for status as to setting a preliminary hearing.
That's correct, Your Honor. We are in negotiations with Ms. Schultz today. Mr. Chapman would waive his right to a preliminary hearing for the offer extended by the district attorney, which is for felony assault in the second degree, the strangulation subsection. That sentencing would be open. Mr. Chapman and I still have some work to do on the case and discussions with regard to disposition, so I'm asking to set over arraignment.
Okay, we'll set the matter over for arraignment. When do you want to schedule it?
I was hoping either January 7th or January 14th, if that works for the court and the Schultz.
Either is fine by the people.
Okay, we'll set it for January 7th at 8:30 for arraignment.
Great, thank you. I also have Rachel LeClaire, I believe is called in, number 31.
And Judge, we have an interpreter matter whenever the court's ready.
Yes, and I know Mr. Allen is also here with his client. So I've got a lot of business to get done before sunset. Okay, this is number 31 on the docket, 19 CR 3017, Rachel
That's
LeClaire.
James to the people.
Nicholas Weber on behalf of with Ms. LeClaire. She can appear by telephone. We consent to a telephone appearance today.
And Ms. LeClaire, can you hear me?
Yes, I can.
And you have the right to appear in person with your attorney today. Are you giving up that right and agreeing to appear by audio conferencing instead?
Yes, I am.
Are you doing that voluntarily, meaning of your own free will?
Yes.
Okay, and the matter is on a deferred judgment revocation.
Your Honor, I did have Ms. LeClaire call in first thing this morning. I know the court is very busy. I do think this is going to go to hearing. I didn't know if the court wanted us to come back and end the docket, or perhaps tomorrow. I'm also in front of Your Honor next Tuesday, whatever the court prefers.
Are the people available tomorrow?
The people are, Judge. I talked to the probation officer. She's available tomorrow and Tuesday both. She's not available Monday.
Okay, we will set this over till tomorrow morning at 8:30.
Thank you, Your Honor. The other one I have is number...
And this will be virtual, correct?
Correct, Your Honor.
Okay, thank you.
And the last quick one I wanted to call was number 50, Ashley Powell.
Number 50 is 19 CR 9037, Ashley Powell.
Good morning, Your Honor.
Good morning.
Your Honor, Nicholas Weber appearing with Mr. Powell, who's on the telephone. We do consent to the telephone appearance today.
And Molly Schultz for Brennan Zortman for the people.
And Mr. Powell, you have the right to appear in person with Mr. Weber today, giving up that right and agreeing to appear by audio conferencing.
Yes, Your Honor.
Are you doing that voluntarily, meaning of your own free will?
Yes, Your Honor.
Okay, Mr.
Your Honor, we're set for arraignment and we're requesting to waive formal advisement, further reading, enter pleas of not guilty, and requesting dispo and motion states.
Okay, the court will accept the not guilty plea. Both sides will have 28 days to file motions. We'll set this for a Thursday disposition, Friday motions hearing. And we can do January 21st, 22nd.
That works for defense.
That's fine.
January 21st at 8:30 for disposition. January 22nd at 8:30 for motions. And Mr. Paul, you still have a warrant out in Arapahoe County.
Yeah, and I've still spoken with them, and I've still reached out to them. We're still working on that, Your Honor.
Okay. Okay. Otherwise, your bond is continued till the days that you just got those days.
Yes.
Okay, Mr. Paul.
So the 21st and the 22nd at 8:30.
Right.
Yes, Your Honor.
And then I'm going to call a private counsel case, the Matlock matter number 38, 20 CR 3830, Carrie Matlock.
Good morning, Your Honor. Richard Ott appearing with Carrie Matlock. She's on with phone number ending in 63.
Good morning, Your Honor. Jane Walsh appearing for the people.
And Matlock, can you hear me?
Yes, ma'am, I can.
And you have the right to appear in person with your attorney, Mr. Ott. Today, are you giving up that right and agreeing to appear by audio conferencing?
Yes, Your Honor.
Are you doing that voluntarily, meaning of your own free will?
Yes, ma'am.
Okay, and the matter is set for arraignment. Is Ms. Matlock prepared to be arraigned?
Your Honor, we'd ask for one more setting on this. We don't have all the discovery on the matter yet.
I typically don't set over arraignment because I end up, when I do, with 91 case dockets like today. So I can, and I know you've already filed motions.
Right. Well, apparently the district attorney's office didn't have that in terms of getting me the discovery, so I only have some of it. And so I have been in discussion with Ms. Walsh. We are working on it. So. But
if I continue, it'll be either till Christmas, December 24th or December 31st. Those are the only days I can give you.
Well, I'd rather not do either of those. So
then we can proceed, and I'll give you 35 days to file motions.
That'll be fine. We'll just do that.
Okay, does she waive formal reading and advisement? In her plea is not guilty?
Correct.
Court will accept the not guilty plea. Both sides will have 35 days to file motions. We'll set the matter down for a Thursday disposition, Friday motions hearing. So we're looking at, we can do January 28th and 29th.
That works for the people.
All right. I cannot do the 29th. I can do the 28th.
So the 28th would be for dispo, and then do you anticipate any evidentiary motions?
Actually, I do. Yeah.
Then what about February 4th and 5th? So the Thursday would be for disposition, the Friday for evidentiary motions.
4th and 5th are fine.
That works.
Very good. Okay, February 4th at 8:30 for disposition, February 5th at 8:30 for motions. Bond will continue until those dates and times. Thank you.
Thank you, Your Honor.
And then we have an
Check and
interpreter. We have
see
an
who-
interpreter matter. Oh, I'm sorry, Ms. White.
I just wanted to see from the Broomfield Jail, is that Michael Wilson?
Yes, Ashley.
Judge, could I have a breakout room with Mr. Wilson, please? And then, so the court's aware, the DOC, one under Brandon Clark, we're just waiting for paperwork to be uploaded. So if I could maybe do breakout room with Mr. Wilson now, and then by the time I get back, we'd be ready to call it?
Yes.
Thank you.
Okay, and then, Mr. Winter, which is the interpreter matter?
The Leonard Wilson matter, Your Honor? Sorry, I don't know the document.
66, Your Honor.
Okay. The court will call number 66 on the docket.
Se llama el caso 66 en la lista de casos.
20 CR 2226, Leonard Wilson.
Matthew Wenning for the people.
Evan Shaw on behalf of Mr. Wilson. Mr. Wilson appears in custody over video. He consents to appearing in that manner.
Okay, Mr. Wilson, can you hear me?
Yes, I can.
And Mr. Wilson, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio video conferencing?
Yes, I am.
Are you doing that voluntarily, meaning of your own free will?
Yes, President.
Okay, in the matter set for sentencing, are both sides ready to proceed?
The people are ready.
The defense is ready as well.
Don't touch it.
And Your Honor, just for the record, Rosemary McCoy, 7043 Spanish interpreter. I'm also interpreting for part of the family through the bridge line, Your Honor.
Thank you.
And that, correct, Judge, a number of the victims are on the bridge line. They don't wish to speak, but they wanted to hear the proceedings.
And my understanding is the stipulated sentence to 24 years Department of Corrections plus 3 years mandatory parole. I'll hear from the people first.
Thank you, Judge. Mr. Wilson was on parole, and his co-defendant were driving a stolen vehicle. They got spooked by seeing an officer that had nothing to do with them. They bailed out of the car in the middle of an intersection, and Mr. Wilson had a gun. He took it to the car in front of them. They tried to get that family out of the car. They yanked the driver, who was wearing a seatbelt. They couldn't get him out of the car. They went to a next car. They put a gun to a head of the driver. The family didn't move fast enough for them. They were kind of paralyzed. They ran together catty corner across the intersection to a bank that was working. It was a drive-through teller. They jumped in a car, they put a gun to a third car driver's head. They got out. Mr. Wilson and his co-defendant got in. They tried to drive away. It turned out it was a stick, and they don't know how to drive a stick. Then they went to a fourth car, and the party got out. It rang out from Mr. Wilson's handgun, and nobody was hit. It was done. It looks like it was done in an attempt to scare the drivers and the people. It was done. The party left. Judge, what Mr. Wilson didn't know, even though the police officer that he saw knew nothing about it, there were undercover officers following him in a number of ways, and they very quickly came in and arrested Mr. Wilson and his co-defendant on the scene. Mr. Wilson was in possession still of the handgun. He was on parole for a very short time. He had 2 prior felony convictions. One of them was an aggravated robbery. We came to this agreement. Mr. Wilson was looking at all the habitual charges. There is a great number of victims. I spoke to each one of them through an interpreter. I think there's at least a dozen. They were all affected. Many of this happened with their families, with their children, as they were getting pulled out of the car. We'd asked the court to impose the 24 years. I realized this morning there was no agreement with Mr. Shaw as to how this would play with the parole. And I don't know if he's still on parole or not. But I think that's something that required. Thank you.
And Mr. Shaw?
That's correct, Your Honor. I asked the court to accept the disposition and impose 24 years. That is a very significant amount of time for Mr. Wilson. Mr. Wilson had an extraordinarily difficult upbringing. He was raised mostly by his mother. His mother was a severe alcoholic, which led to Mr. Wilson a lot of raising of himself. He was born in a neighborhood, raised
Hello, what happened? Got kicked out of the courtroom for some stupid reason. We're back in court, folks. Sorry.
Hopeful that he can get it right this time. He does not have an extensive criminal history. I think part of that is obviously the amount of time he has spent in custody in his adult life. But Mr. Wilson is committed to getting things right, and Mr. Wilson really does want to make a change. He got a glimpse of what family life is like. That's something he never experienced growing up, but it's something that he very much wants. We would ask that the court consider running this concurrent to his parole sentences. He finishes his parole on December 30th, so it does not make a huge difference. Those case numbers are 02 CR
I have the numbers.
1085.
I have all the numbers.
And we would also ask that the court note 252 days of pre-sentence confinement.
And Mr. Winnick, I neglected to ask you if there's any restitution.
And Judge, there is no restitution, and obviously, if the court chooses to run a concurrent, I think he gets the 252 if it's consecutive. I don't think he does, because that would be applied to his parole.
And Mr. Wilson, is there anything you want to tell me?
No.
Okay, the matter's before the court for sentencing, and it's an appropriate disposition. For the facts of the case are egregious, and I can't imagine the fear that the victims underwent and probably continue to feel to this day. I will follow the agreement. It's 24 years Department of Corrections plus 3 years of mandatory parole. And because the MRD date is so soon, I will run it concurrent to 02 CR 1085 and 14 CR 10085, both Denver cases. I'll note 253 days pre-sentence confinement, and it'll be noted on the minimus, but it'll be most likely applied to the other cases. So, Mr. Wilson, while I'm noting it, it's up to the Department of Corrections whether to give any credit, and under the law, it'll be applied to your case sentences you're already serving. The court will waive any fees, costs, and surcharges that are waivable and find that there's no restitution. And Mr. Wilson, while your record may be not lengthy, it's very serious. So I hope you do what your attorney said and do your time differently this time. Okay.
Thank you.
Anything further?
No, Judge, thank you.
Defense is remanded.
Your Honor, I do have an in custody matter. Duran Castoreno. He is number 9 on the docket.
Okay, number 9 is 20 CR 4306.
James and Nicholas Weber, Offset Public Defender, on behalf of Mr. Duran Castoreno. He does appear by video, and we continue to appearing in this manner.
And Mr. Duran Castoreno, can you hear me?
I can hear you.
You have the right to appear in person with Mr. Weber, your attorney. Today, are you giving up that right and agreeing to appear by audio-video conferencing? So you have the right to appear in the courtroom with your attorney. Because of the pandemic, the court is, and to keep everyone safe, the court is conducting most hearings by audio-video. But I have to make sure that you agree to appear by audio-video.
Yeah, I agree.
Are you doing that voluntarily? Of your own free will?
the court appearance on the computer, are you okay doing that?
Oh, yeah, yeah.
Okay. She's asking if you're doing that
Wanted to make
voluntarily.
sure, wanted to make sure I'm
Okay. And just off the record, I think Ms. White needs help getting out of the breakout room. Am I staff? Okay, so the matter is set for arraignment today, and it's my understanding the bond has also been reserved.
That's correct, Your Honor. If the people are in VRA, we would request to address bond in this case, and then we would be asking to enter pleas of not guilty and set for disposition and motions hearings. I was looking at January 21 and 22. That's still available.
Okay, let's go. Why don't we do that first? He waives formal reading and advisement.
He does, Your Honor. He does.
Okay, the court will accept the not guilty plea. Both sides will have 28 days to file motions, the 21st at 8:30 for disposition, the 22nd at 8:30 for motions. And then regarding bond?
Thank you, Your Honor. Defense counsel, obviously the allegations in the case are extremely serious. Defense counsel would ask the court to consider a reduction of bond or a lower cash option so that he can communicate with family. What we wanted to let the court know is part of the delays at the preliminary hearing level for Mr. Duran Castoreno really involved getting our hands on video surveillance. I do think would be very helpful as the case moves forward, and obviously it's an issue for litigation if it becomes something that ends up being trial bound. But what is clear from the video surveillance is that although he's accused of using a firearm to shoot at somebody, the video surveillance is not clear as to who is doing what. And then there's also not just one victim and one shooter. There is a whole mess of people in an alleyway, and the alleged victim in the case approaching a large group, carrying what looks like some sort of sword or a machete, and is moving in a directive, and sort of acting in a way that would be certainly felony menacing, I think, at a minimum. And then there are more than one shooter, and it's hard to positively say that this person is definitely Duran Castoreno or not. There is other video surveillance from inside a hall that looks more like Mr. Duran Castoreno, but the clothing is very different. So I think there is an identity issue at stake that I would ask the court to take into consideration that defense really didn't have access to in terms of the video surveillance up until the last preliminary hearing setting when we were finally able to get our hands on that through the discovery channels. The other thing that I would ask the court to take into consideration is that Mr. Duran Castoreno is married, and he and his partner have a small child, and they have been able to, and his partner has been able to obtain an apartment that is nowhere near this part of town. I think the arrest affidavit from the detective makes it sound like this is a constant activity, and they've repeatedly gone back to this apartment complex on calls for issues. And Mr. Duran Castoreno doesn't live anywhere near there. So I think if the court were inclined to address the bond in some way, I think even just a GPS and given the seriousness of the case could alleviate any of the people's fears about any continuing issues.
Well, it's already set at maximum supervision.
Right, and I think that would be appropriate. I'm just asking her to have the opportunity to handle this case living at home with his partner and young child.
People's position?
Judge, the people object to the bond reduction. The first reason for that is that bond in this case was last argued on October 19th. Sorry, I'm getting my dates mixed up. It was argued on October 12th. And bond was modified at that time. The people don't believe that the statements by the defense represent the new grounds to argue bond. Additionally, the people don't think that there's been a written motion to address bond that was filed, even though bond was reserved previously. And finally, Judge, I would note that the information that I think is in the police reports about Mr. Duran Castoreno indicates that he does live in the area where this does or did live in the area where this offense occurred, and or at the very least has family there, and him being in this area was a significant concern to the investigators and the other folks who were dealing with this case. Ultimately, the people believe that current bond is appropriate based on the facts in the case and the other circumstances, and the current bond is necessary and appropriate to preserve the public safety.
Okay, and the court.
Can I say something? Can I say something?
Mr. Drancaster would not make any statement, please.
Okay, the court is going to deny the motion to reduce bond or modify bond, finding that, one, it was addressed on October 12th. Additionally, the court finds, based on the CPAT Category 3, the nature of the charges, the significant criminal history, which included several burglary convictions as well as third-degree assault, that the bond is appropriately set. Okay, so if there's nothing further, defendant's remanded.
Thank you, Your Honor.
Thank you.
Do we have a writ calling in from the Arapahoe County Jail? Is that Anthony Martinez?
Is Anthony Martinez present from Arapahoe County Jail?
Yes, Your Honor.
And Mr. Weber, do you need to go in a breakout room, or are you ready in that case?
If I can, please, Your Honor. Thank you.
You want a breakout room?
Yes, please.
So we'll have Anthony Martinez. That's Tony Martinez, right? Number 37.
I think it might be Anthony Martinez, number 60.
Oh, okay. It's a 9 o'clock one, yes. So it's number 67. So we'll have Mr. Martinez moved in and Mr. Weber moved. It looks like they're already being moved.
And Judge, I'm going to get our DOC writ number 1, Mr. Aguilar.
Okay. Okay, number 1 is 20 CR 5281, People versus Aguilar.
Tim Hoffman on behalf of the people.
Ashley White from the Public Defender's Office on behalf of Mr. Aguilar, who appears via virtual writ from DOC today. We do consent to a virtual appearance. We have disposition.
And Mr. Aguilar, can you hear everyone?
I can.
And you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio-video conferencing?
I am.
Are you doing that voluntarily, meaning of your own free will?
Yes.
Okay, it looks like there's a disposition to added count 4, criminal attempt to commit second-degree burglary. And is there a sentence stipulation?
Yes, Judge. It's a stipulation to 2 years of DOC concurrent to a Denver and Jefferson County case that are both listed on the paperwork.
Okay. Then, Mr. Aguilar, I'm going to advise you of your rights. First, please tell me your full name.
Lionel Angel Aguilar.
And how old are you?
39.
How far have you gone in school?
I got my GED.
Good. Do you read, speak, and understand the English language?
I do.
And are you understanding me as I'm speaking to you today?
Yes, ma'am.
Are you thinking clearly?
I am.
Have you taken any prescription medicine?
No, ma'am.
Are you under the influence of any street drugs, alcohol, or marijuana?
No.
Are you suffering from any mental or emotional condition that would make it difficult for you to understand what's taking place?
I'm sorry, can you repeat that?
I'm sorry, someone was speaking. Let me make sure everybody's muted. Are you suffering from any mental or emotional condition that would make it difficult for you to understand what's taking place?
No, ma'am.
The court's understanding of the disposition. Well, one more question. Are you serving in the United States Armed Forces, or are you a veteran?
No, ma'am.
The court's understanding of the disposition is that you will be pleading guilty to added count 4, criminal attempt to commit second-degree burglary. It's a Class 5 felony. There's an agreement you would receive a 2-year sentence to the Department of Corrections plus 2 years of mandatory parole that would run concurrent, meaning at the same time as your your other sentences. Is that your understanding?
It is.
Is that how you wish to proceed?
Yes, ma'am.
Have you discussed this with Ms. White?
I have.
Are you satisfied with her representation of you?
I am.
The charge you're pleading guilty to says that between and including approximately May 12, 2020 and May 13, 2020, by engaging in conduct constituting a substantial step toward the commission of second-degree burglary, you unlawfully, feloniously, and knowingly attempted to break an entrance into, enter, or remain unlawfully after a lawful or unlawful entry in the building or occupied structure of Taylor Meyer and Alexan Cherry Creek Apartments located on Cook Street with the intent to commit therein the crime of theft. To that count, what is your plea, guilty or not guilty?
Guilty.
Before I can accept a guilty plea, I have to make sure you understand all of your rights and the effects of your guilty plea, and I've been provided with a petition to enter plea of guilty and plea agreement. Did Ms. White read it to you and answer any questions you had about it?
Yes, she did.
And Ms. White, is that correct also as to the elements?
Yes, Judge.
I'm going to go through those rights with you. You have the right to be represented by counsel at all stages of a criminal proceeding, not just today at a disposition, but any trial as well. If you're determined to be indigent, counsel is appointed to represent you at no cost to you. You have the right to a speedy and public jury trial. At that trial, you would be presumed innocent. The district attorney must prove your guilt by proving all the elements of the charge beyond a reasonable doubt to all 12 members of a jury, because any jury verdict must be unanimous. At trial, you would have various personal rights: the right to testify, the right not to testify, the right to make the choice whether to testify or not, the right to subpoena and call witnesses on your own behalf, to cross-examine and confront witnesses who testified against you, and the right to appeal to a higher court if you were convicted at that trial. Do you understand those rights?
Yes, ma'am.
And do you understand when you plead guilty, you give up all those rights?
I do.
Now, before you could be found guilty of this charge, the people have to prove the elements of the charge beyond a reasonable doubt. And I read the elements to you when I read the charge. And Ms. White has further indicated that she's read to you and answered any questions you have about the written advisement of the elements. And I've received a written advisement of criminal attempt and a written advisement of second-degree burglary of a building. Again, you're pleading guilty to criminal attempt to commit second-degree burglary of a building. Ms. White has reviewed those elements with you and answered any questions you have about them?
She has.
And do you understand the elements of the charge to which you're pleading guilty?
I do.
Do you understand when you plead guilty, you admit those elements and give up any defense you may have?
Yes, ma'am.
You're pleading guilty to a Class 5 felony. You were on parole at the time, so the sentence range is 2 to 6 years Department of Corrections plus 2 years of mandatory parole, possible fine of up to $100,000. Do you understand the possible penalties?
Yes, ma'am.
Are there any promises that have been made to get you to plead guilty other than the promises told to me in court today?
No, ma'am.
Is anyone forcing you to plead guilty?
Not at all.
Is the decision to plead guilty your own free and voluntary decision?
It is.
And is there a waiver of a factual basis?
Yes.
Oh,
Do you have any questions about your guilty plea?
no.
Do you still want to plead guilty?
Yes.
Court will note that there was a Rule 5 advisement: accept the plea, make written findings regarding acceptance of the plea. Judgment of conviction enters on count 4. Counts 1 through 3 are dismissed. And both sides waive a pre-sentence report.
Yes.
And on behalf of the people, I'm comfortable with the disposition. Is there any restitution?
Mr. Hoffman, you're muted.
I apologize. My wife often wishes she had that button for me. I don't have anything else to add. I'd ask to reserve restitution for an appropriate amount of time.
Okay, and Ms. White, anything further?
This was a somewhat frustrating situation as Mr. Aguilar pled in this courtroom a couple months back, and we were unaware that there was a second case coming down the pipeline with the state of offenses from last spring. As soon as we were aware of it, we did everything we could to get him into here. We actually pulled it out of 4C without him even appearing, because we knew we could resolve it quickly. Mr. Aguilar wants to get this put behind him. We are hopeful there's nothing else coming. I have run all the checks that I can. We don't see anything else, but hopefully this is it. I would note he does have pre-sentence confinement credit of 94 days. I would ask the court to put that on the minimus.
And Mr. Aguilar, anything you want to tell me?
No, ma'am.
Okay, then, Mr. Aguilar, I'm going to sentence you to 2 years Department of Corrections plus 2 years of mandatory parole, credit for 94 days. I'll note 94 days pre-sentence confinement. It'll probably be applied to the other cases, but it will not affect your out date, or should not. I will waive any fees, costs, and surcharges that are waivable. Grant the people 49 days to file a restitution request with a conferral paragraph. If none is filed, the court would find no pecuniary loss. And the sentence will run concurrent with Jefferson County 19 CR 1117, 20 CR 2487, and then Denver County 20 CR 4000. Okay, good luck to you, Mr. Aguilar.
Thank you.
And Judge, we're also ready on the Broomfield writ. That is Micah Wilson. And Mr. James, I did just send you an email back, if you're listening.
I will look at that now.
But Judge, we can call it in the meantime.
And what number?
I'm sorry, it's number 71.
Dockets have gotten complicated to find cases. Okay, number 71 is 19 CR 6886, Micah Wilson.
Matthew James of the People.
Ashley White from the Public Defender's Office. On behalf of Mr. Wilson, who appears virtually via writ from Broomfield County, we do consent to a virtual appearance. We have a disposition. We are asking to set over sentencing.
And Mr. Wilson, can you hear everyone?
Yes, ma'am.
And Mr. Wilson, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio, video conferencing? I didn't hear your response.
Yes, ma'am.
Are you doing that voluntarily, meaning of your own free will?
Yes, I am.
Okay, and the plea agreement you've reached is, if you want to tell me?
Judge, this is the agreement for a class 5 felony of menacing. There's a waiver of the 2 prior felony rule with a stipulation to it running concurrent to a Broomfield case. That case number is included on the paperwork. We are asking to set over sentencing, and Mr. James and I are emailing right now trying to figure out a date and that, but we can start with the plea colloquy in the meantime.
Okay, then, Mr. Wilson, I'm going to advise you of your rights. First, please tell me your full name.
Michael Wade Wilson.
And how old are you?
36.
How far have you gone in school?
I've got my GED.
Do you read, speak, and understand the English language?
Yes, ma'am.
And are you understanding me as I'm speaking to you today?
Yes, ma'am.
Are you thinking clearly?
Yes, ma'am.
Have you taken any prescription medicine?
No, ma'am.
Are you under the influence of any street drugs, alcohol, or marijuana?
No, ma'am.
Are you suffering from any mental or emotional condition that would make it difficult for you to understand what's taking place?
No, ma'am.
Are you serving in the United States Armed Forces, or are you a veteran?
No, ma'am.
The court's understanding of the disposition is that you will be pleading guilty to original count 2 menacing, a class 5 felony. Count 1 will be dismissed. Sentence is open, meaning the court can impose any sentence that's legal and appropriate. However, will run concurrently, meaning at the same time as any sentence imposed in Broomfield case number 19 CR 339, and the people are waiving the 2 prior felony rule with regard to your sentence in 19 CR in regard to this sentence. Is that your understanding of the disposition?
Yes, ma'am.
Is that how you wish to proceed?
Yes, ma'am, it is.
Have you discussed this with Ms. White?
Yes, I have.
Are you satisfied with her representation of you?
Absolutely.
The charge you're pleading guilty to says that on or about August 23rd, 2019, that by any threat or physical action you unlawfully, feloniously, and knowingly placed or attempted to place Dylan James in fear of imminent serious bodily injury by use of a deadly weapon or any article used or fashioned in a manner to cause a person to reasonably believe the article was a deadly weapon, namely a handgun. To that count, what is your plea, guilty or not guilty?
Guilty.
Before I can accept the guilty plea, I have to make sure you understand all of your rights and the effects of your guilty plea. And I've been provided with a Rule 11 advisement, a request to plead guilty. Did you review that with Ms. White by her reading it to you and answering any questions you had about it?
Yes, ma'am.
I'm going to go through those rights with you. You have, and Ms. White, if you can confirm that you reviewed the plea paperwork with him, answered questions, and also the elements? Both.
Yes, Judge, and I'm sorry, I'm on the phone with Mr. James talking about our sentencing right now, but yes, and he has no further questions.
Okay. I'm going to go through those rights with you. You have the right to be represented by counsel at all stages of a criminal proceeding, not just today at a disposition, but any trial as well. If you're determined to be indigent, counsel is appointed to represent you at no cost to you. You have the right to a speedy and public jury trial. At that trial, you would be presumed innocent. The district attorney must prove your guilt by proving all the elements of the charge beyond a reasonable doubt to all 12 members of a jury, because any jury verdict must be unanimous. At trial, you would have various personal rights: the right to testify, the right not to testify, the right to make the choice whether to testify or not, the right to subpoena and call witnesses on your own behalf, to cross-examine and confront witnesses who testified against you, and you would have the right to appeal to a higher court if you were convicted at that trial. Do you understand those rights, Mr. Wilson?
Yes, ma'am.
And do you understand when you plead guilty, you give up all those rights?
Yes, ma'am, I do.
Now, before you could be found guilty of this charge, the people have to prove the elements of the charge beyond a reasonable doubt. And I read the elements of menacing to you and I read the charge, but they're explained in more detail in a written advisement. Ms. White has confirmed that she read them to you and answered questions you had about them. Is that correct?
Yes, ma'am.
And do you understand the elements of felony menacing?
Yes, ma'am.
And do you understand when you plead guilty, you admit those elements and give up any defense you may have?
Yes, ma'am.
And counsel, is there any enhancement or aggravation? He was on parole, correct?
That's correct, Judge.
So you're pleading to a Class 5 felony. It carries a sentence between 2 to 6 years Department of Correction, plus 2 years of mandatory parole, a possible fine of up to $100,000. Do you understand the possible penalties?
Yes, ma'am.
Are there any promises that have been made to get you to plead guilty other than the promises told to me in court today?
No, ma'am.
Is anyone forcing you to plead guilty?
No, ma'am.
Is a decision to plead guilty your own free and voluntary decision?
Yes, it is.
And there's a factual basis, Ms. White?
We waive.
Do you have any questions, Mr. Wilson, about your guilty plea?
No, ma'am.
Do you still want to plead guilty?
Yes, ma'am.
Court will note there was a Rule 5 advisement: accept the plea, make written findings regarding acceptance of the plea. Judgment of conviction enters on count 2. The other counts are dismissed. We'll set the matter for sentencing. Do we need a pre-sentence report?
Can we argue it?
And Judge, Ms. White and I were literally just talking about that while the court was doing the plea colloquy. The people's position is that I would prefer to have a PSI. Ms. White is concerned that she wants to be available to complete the sentencing in this case, and is concerned that a PSI might not be done in time. And I can let her make any further record that she wants to make about that.
And so, Judge, we are asking for...
We can have a PSI by January 7th.
Okay, so we are asking for a divert screen as well. We were hoping to do a divert screen and use their sort of mini PSI that they create and set this on December 31st. And that's what I've been trying to beg Mr. James to agree to. And so I think I guess I don't know where we ended with our conversation, but then if for some reason he's rejected from divert, then I think it would be fine to request a PSI and we could set it out for that. But I think that the sort of mini PSI they create for divert still sort of would satisfy the district attorney's request for a PSI, and it would allow us to get this case resolved. I can tell the court that all three of Mr. Wilson's other cases in other counties are resolving next week, and the Broomfield case will be concurrent to here, and they will be getting a community correction screen, which they believe would be done by the 31st as well. And so we were hoping to be able to have everything sort of wrapped up and go to sentencing in front of this court on the 31st.
I'm not going to have probation do two reports. So it'd be one or the other. So if he's rejected from divert, well, first of all, the people have to agree to an ASR, and if they're not, I will order a PSI. Then we can do a PSI and a divert. And I think if we did that, it would probably be about the 21st of January 21st.
And Ms. White, maybe I misunderstood your dates of availability, but I thought you would be available then.
I theoretically should be available then. I am still asking you to consider doing the ASR instead of a full PSI.
And Judge, the people, based on the facts in the case, the people are going to request a full PSI.
So that would put us at January 21st, a PSI plus a divert screen.
And that's fine. If I can just explain that to Mr. Wilson. Mr. Wilson, the district attorney is requesting a full pre-sentence investigation report. And so you'll still get the divert screen, but instead of having a court date on the 31st, it's going to be pushed out until January 21st. And if you have further questions about that, you can call me. But that PSI should be completed. Judge, I would ask for the minutes to reflect that he will be housed in Broomfield, and so that would be out of county. And we will need a writ for sentencing.
Yeah, a minute. Oh, I need a release of information from Mr. Wilson. So Mr. Wilson, to do the divert screen, the probation department needs, and I don't have a copy of the release of information in front of me, so I need to get it first. So, Mr. Wilson, for divert to do a screen, they need to have you waive your right under basically HIPAA to release information regarding your mental health, drug and alcohol treatment to the judge, to the prosecuting attorney, the mental health center at Denver, your lawyer, and all other facilities, including probation in the Denver County Jail. And that would be agreeing to release diagnosis information, attendance, drug and alcohol testing results, clinical termination data, medical history, clinical progress data. Are you agreeing to do that?
Yes, ma'am.
Are you doing that voluntarily? Okay, then we will do a virtual to Broomfield unless his location changes. Please advise us immediately, but otherwise it will be for the 21st. Thank you, Mr. Wilson. Video 20-5491, Anthony Martinez.
Watson for the people.
Nick County Jail, we consent to appearing this way.
Okay, and Mr. Martinez, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio? Are you doing that voluntarily, meaning of your own free will? Okay, and the matter is set for sentencing. Are both sides ready to proceed?
Yes.
Yes, Your Honor.
And I'll start with the people.
Governor, the PSI here talks about the prior offenses and the nature of this offense. People's concern, certainly the weapon, but more so the gun that was loaded and on Mr. Martinez's hip at the time of contact with the police. I think the fact that he was forthcoming with the officers was a good thing. However, he admitted that he knew that because of his prior criminal history, not entitled or not lawfully entitled to carry a gun such as the one that he had. Given all of that, the prior felonies, I'd ask the court to sentence him to 18 months in the Department of Corrections.
Okay, and on behalf of Mr. Martinez, then I did add additional 28 days of pre-sentence confinement because the bond should have been released on November 12th because I did not have a consent of surety. So it's 61 days pre-sentence confinement.
Thank you, Your Honor. Defense counsel is asking for the minimum in the Department of Corrections on the Alpo. As Mr. Luxon flagged for the court, I do think the fact pattern in this case is mitigating in that police officers find out about this motor vehicle. They contact both Mr. Martinez and the other individual. Mr. Martinez is very forthright with law enforcement. He doesn't even have an ID or driver's license on him. But he doesn't give them any kind of fake name or any of that nonsense. Gives them his name and tells them, I think I have a misdemeanor warrant out right now, which they checked and he did. He was very forthcoming with the firearm in his van. Also told police officers about, I think it was 1.2 grams of meth that was in his coin pocket as well. I think when we look at his criminal history, some of the older things on Mr. Martinez's criminal history are certainly more concerning. I think the incidents from 2017 and of late really suggest somebody who's struggling with a drug addiction, a methamphetamine addiction. And I know that Mr. Martinez has been working on that sobriety. Obviously, he's been in continuous custody. He has two warrants out of Adams that he still needs to handle for misdemeanor matters, but they're set to be, I think, heard next week. And he's going to wrap up all of those cases as well. He's very bright, and when I've spoken with him, he's got plans for his future in terms of got his GED. He's already looking into how he can sign up for credits once he gets released from custody. So he does have plans in the future. I'm just asking the court not to impose too hefty of a Department of Corrections sentence so that he can get all his cases wrapped up. I don't even know when DOC he's going to come pick him up just because of transportation issues and COVID, etc. And then asking for the court to note the sentence confinement credit.
And Mr. Martinez, anything you want to tell me?
Your Honor, I'm just really, I got my main focus on trying to go through policy and become a pastor. That's my main focus. So, like, anything in my past, I apologize for. I didn't mean for none of it. I do got a drug problem. I had a drug problem. I'm trying to fix it. I've been just mainly just focusing on now, not my past, and I'm doing pretty good right now. I've never had I've never had the train of thought that I had now. I've always wanted just to get out and go do the same things I was doing. I ain't never had no plans or nothing before. This time I got plans. And my mother really needs me out there. My father just passed away 4 months ago. And like I'm the only man of our family, and my mom really needs me by her side. That's all, Your Honor.
Thank you. And Mr. Lux, I take it there's no restitution?
That's correct. As the PSI noted, and I think was discussed at the time of the plea, the gun will be destroyed.
Yes, and there was an agreement to have the gun destroyed, and it will be. The court will, having reviewed the pre-sentence report and hearing statements, will sentence Mr. Martinez on the felony to 18 months Department of Corrections plus 1 year of mandatory parole, credit for 61 days pre-sentence confinement. And I find that sentence to be appropriate based on the facts of the case, possession of a weapon, particularly in light of Mr. Martinez's prior criminal history and the manner in which it was on his person. On the misdemeanor count, the court will sentence him to 6 months in the Denver County Jail that can be served in the Department of Corrections. Again, credit for 61 days pre-sentence confinement, and those two sentences are concurrent to each other. The court will find that there's no restitution and will otherwise waive fees, costs, and surcharges that are waivable. And good luck to you, Mr. Martinez, and thank you to Arapahoe County Jail. Yes, Ms. Martinez?
So, am I gonna stay in, as soon as I'm done with my Arapahoe County case, I'll get moved to Denver County?
No, you won't, no, because the jail sentence can be served in the Department of Corrections. You don't have to do it in Denver.
Okay, so it's run concurrent?
Yes, they're concurrent, yes.
So I could be leaving any day from Arapahoe County?
No, it's up to Arapahoe County. You'll until your case there is resolved, it'll be up to Arapahoe County, and I know there's a backlog at the Department of Corrections.
Okay, so on the new sentence for the Denver case, how much time do I got in credit?
60, I think it was 61 days.
Alright. Even though
Okay.
it's not concurrent?
Yes,
That's all.
that's how it's done. Okay?
Thank you.
Okay, good luck to you, sir.
Thank you, Your Honor.
Okay, thank you.
Sorry, we have a Denver County Jail inmate from a protocol unit calling in.
Which
Michael
case?
Avery. Michael Avery.
Okay.
Sorry.
Okay, then that would be number 4 in the docket. 4 is 20 CR 2974. Michael Avery.
Andrew Luxon for the people.
And Luke Levelis on behalf of Mr. Avery. He is present in custody by phone, appearing from the county jail.
Is he in the, Mr. Avery, are you present?
Yes, ma'am.
And Mr. Avery, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio conferencing?
That's correct.
Are you doing that voluntarily, meaning of your own free will?
Yes, Your Honor.
Okay, the court, matters before the court on competency, and first of all, I'm not seeing Mr. Avery. He is in jail on another matter, or on this matter?
On this matter.
Okay. And I'm not seeing you, Mr. Avery.
So, I think because he's in a protocol pod, they are not able to have him provide video.
Okay. And the court has received a report indicating that Mr. Avery is competent to proceed. Does either side contest that report?
No, Your Honor.
And the court would find that Mr. Avery is competent to proceed, and did he reserve a PH? No, PH was waived on June 26th. So we're at arraignment stage now.
Your Honor, I'd ask to enter a not guilty plea, waive any advisement from the court. I'm going to ask to set a little bit further out than typical for disposition and motions, just because given the competency evaluation status and other issues with getting visits with Mr. Avery, I haven't had as easy access to him as I certainly like, and I just want to make sure that I'm able to have a longer meeting with Mr. Avery before he reaches those critical stages.
Okay, then, does he also waive reading of the charges?
He does.
Court will accept the not guilty plea. Both sides will have, I'll give you 35 days to file motions. We'll set this for a Thursday disposition. Do you anticipate evidentiary motions?
I do.
So we can do January 28th and 29th, or February 4th and 5th.
My preference would be the 4th and 5th of February.
Does that work, February 4th and 5th?
Thank you.
Does that work for the people?
Yes, thank you.
February 4th at 8:30 for disposition, February 5th at 8:30 for motion.
Your Honor.
Defendants remanded.
Your Honor, also in custody, I believe we have Angelita Trujillo, number 62.
Okay. Number 62 is 18 CR 8941, Angelita Trujillo.
Andrew Luxon for the people.
And Nicholas Weber standing in for Erica Unger, Office of the Public Defender. Mr. Trujillo appears by video from the jail. Would you consent to appearing in this manner?
Okay, and Mr. Trujillo, can you hear me? And Mr. Trujillo, you have the right to appear in person today. Are you giving up that right and agreeing to appear by audio video conferencing?
Yes.
Are you doing that voluntarily, meaning of your own free will?
Yes.
Okay, and the court has received a report. She has been accepted in the SEBR program, so I will authorize a PR bond. She's, as a condition of that bond, she shall participate in treatment restoration classes and adhere to medication recommendations. She's been accepted to the Stout Street residential facility, and she'll be required to abide by their rules and regulations. She'll work with SEBR program staff to secure permanent housing. Transportation to support services will be coordinated by SEBR. She will contact SEBR program staff a minimum of 2 times per week, and she'll be released to the SEBR on December 15th at 12:30. So, and so that's next Tuesday. So we'll set the matter down for review of competency. The mental health stay will continue, and that review will be in 90 days. March 11th, 2021 at 8:30.
Thank you.
Okay, so you understand all of that, Mr. Trujillo?
Yes.
Okay, thank you.
Thank you, Your Honor.
Okay, and then I know we have a private lawyer who's been waiting, so let me see. And that is the Ortiz case. So I'll call the Ortiz case, which is number 46 on the doc, except we need a Spanish interpreter for that. Do we have a Spanish interpreter?
Your Honor, I don't believe we need one because I can't get hold of my client, so we want to move forward with this.
We'll call number 46, 20 CR 3058, Ortiz Ramos.
Tim Hoffman on behalf of the people.
Michael Such on behalf of Mr. Ortiz Ramos, 31058, hearing on WebEx.
And he is not present?
No, Your Honor. We had previously had contact with him, and we were under the agreement that he would be in our office this morning at 8 a.m. to sign the papers for an agreed disposition, but we can't get hold of him. He did not come to the office today.
Do you want to wait, or do you want me to issue a warrant now?
Yeah, we've been waiting, and we cannot get hold of him. So at this point, there's nothing more we can do today. So I understand.
Well, no,
I
would, if you want to give him time to still appear, I'll set it over till 1:30. Otherwise, I'll issue a warrant now.
That'd be great if you want to set it over till 1:30. Let me just double check my calendar here. Yeah, I have a 2:30, but I can come in on 1:30.
Yes, we'll continue this to 1:30, and at that time, if you don't have contact with him, we'll issue a warrant.
Thank you, Your Honor.
Okay, thank you. And let me go through some of these call-in users. I have call-in user 3035, last 2 digits 92. Whose number is it, please? 303. Thank you, Ms. Joy. And then I have 3036, last two digits 54. Whose number is that?
Hello?
What's your name?
This is Darren King.
Thank you, Mr. King.
Judge,
And then I have,
Mr. Higgins is ready to call that whenever the court's ready.
okay, let me just get these other folks identified. I have 3038, last two digits 77.
Yes.
What's your name, please? (3038), last two digits 77. What is your name, please?
Kenyatta Nix. Last name Nix.
Thank you, Mr. Nick.
And yes.
Okay, then I have 7203, last two digits 41. Whose number is that?
Smith.
Your first name?
Michael.
Michael Smith. Thank you.
Mr. Smith, this is your lawyer. I'm going to ask you to hang up so we can talk. What's the phone number I can reach you at? Call you.
All right.
Okay, then I have 7204, last two digits 13. Whose number is that, please? 7204, last two digits 13. Okay, then I have 7204, last two digits 31.
That's going to be Mr. Story out of Denver County Jail.
Okay, are we ready on the Story case?
I'm ready, Your Honor. I don't know if Mr. Hoffman is.
I'm here, Your Honor.
Okay, if we have Mr. Story in custody, we'll call number 58. 58 is 20 CR 3589, Alfred Story.
Tim Hoffman on behalf of the people.
Don Martin on behalf of Alfred Story, Your Honor. We're appearing via WebEx. He's in custody and I'm in my office, and we
Okay, Mr. Story, can you hear me?
Yes, ma'am.
And Mr. Story, you have the right to appear in person with your attorney today. Are you giving up that right and agreeing to appear by audio conferencing?
Yes, ma'am.
Are you doing that voluntarily, meaning of your own free will?
Yes, ma'am.
Okay, and the matter is set for disposition, and it looks like there is not a disposition.
Your Honor, Mr. Hoffman and I have been going back and forth on this. There are some complications to this. Mr. Story is on parole, and Mr. Hoffman gave me an offer the other day. I couldn't convey it to Mr. Story until last night, and he agreed that he would accept it. It's a plea to criminal mischief. Criminal mischief. And I don't have the paperwork yet. What I'd ask the court to do is just put this over for a little bit, and I'll, Mr. Hoffman can give me the paperwork, and I'll go over it with Mr. Story.
And do you agree to toll speedy trial for the next court date?
Yes, Your Honor.
Speedy trial will toll. I can do December 24th at 8:30.
I'm gonna be. Yeah, I appreciate the fact that you're working, Your Honor, but unfortunately, this old guy is going to go to visit his kids in Florida for a couple of weeks.
December 31st.
I'll be back January 3rd.
Your Honor, if it sounds like the court has a light docket tomorrow, I can get this paperwork prepared in the next hour or so, and over to Mr. Martin if the court wants. If that works for Mr. Martin, we can set it over just for a day.
That'd be fine.
Okay, well that's great. We can set it over till tomorrow.
Thanks, Your Honor. Mr. Story, is that okay with you?
Yeah, that's wonderful. That's
Mike, I won't be able to go over the paperwork with him. I have to get it to him first.
okay. How about can we? Can Mr. Martin? Would
you be able to call me in the morning right before court and read down to me what it
Actually, yeah, I can do that if the court will allow me to, if he gives me permission to sign the paperwork on his behalf, will the court accept that?
Yes, that's what a lot of the attorneys are doing.
Then let's do that. Tomorrow's great.
because our pod just went on quarantine lockdown again about an hour ago.
Okay.
Okay, so Mr. Story, we'll see you tomorrow.
Yes,
At what time, Your Honor?
8:30?
You know, it's not the one girl, I don't know if you know.
I'm sorry, what?
8:30 tomorrow?
That's fine, Judge, yeah.
Okay, thank you.
I'll see you.
What I'm going to do is continue to identify the call-in users, and then we'll do Mr. King's case. So the next one I have is 7204, last two digits 13. Whose number is that, please?
Mr. Martin, Ricky Martin?
Thank you, Mr. Martin. Then I have 7205, last two digits 47.
Greer.
Thank you, Ms. Greer. Then I have 7205, last two digits 53. Thank you. And then I have 7206, last two digits 41. Whose number is that, please? 7206, last two digits 41. And let me go back to, go ahead.
I'm sorry, was that the phone number you're reading out?
Yes.
That's not it. His is 14, I'm sorry.
7206, last two digits 41.
Yes, that's Eugene Parker.
Thank you. And let me call that other one. My clerk didn't get the name. 7205, last two digits 53.
Matthew Garcia.
Thank you, Mr. Garcia.
No,
And then I have 7207, last two digits 02.
Here, Ornelas.
Thank you, Mr. Ornelas. Then I have 7207, last two digits 27.
Billy Gonzalez.
How do you spell your last name?
Gonzalez.
Thank you. Then I have 7207, last two digits 76.
Nicole Stack.
Thank you, Ms. Stack. Then I have Stack. So then I have 7207, last two numbers 84.
Yes, ma'am, Your Honor.
What's your...
Judge, that's Bruce Chrome, number 28 on the docket, and we're ready.
Thank you. Then I have 7207, last two digits 98.
That's me, Ricky Martin.
Thank you, Mr. Martin. Then I have 7208, last two digits 23. Whose number is that? No response. And I have 7208, last two digits 49. Whose number is that, please? 7208, last two digits 49.
Mendoza, Frank, and I already have been on. He just forgot to ask something. He told me to call back to be listening to ask what was.
Okay, Mr. Mendoza, thank you. Then I have 8166, last two digits 08. Then I have 9158, last two digits 62. Whose number, please? Okay, we'll next call the King matters. Those are 25 through 27. 19 CR 5361, 20 CR 311, and 20 CR 4282, Darren King.
Brenna Zortman for the people.
Lyndon Hagan, something happened, Mr. King, who does appear.
And Mr. King, good morning. Can you hear everyone?
Darren, you might have to unmute *6.
I'm not seeing him.
Do we lose him?
Oh no.
Okay, we'll pass the matter. I'll call the Chrome. Well, first of all, we have somebody in jail. We have some folks in jail. I'd like to take care of the in custody first.
The in custody matter is Bishop Williams, Your Honor.
Okay, we'll call that case then.
65.
Okay. Number 65 is 20 CR 5869, Bishop Williams.
And Nicholas Weber.
Morgan for the people.
And Nicholas Weber with Mr. Williams, who appears virtually. We consent to appearing in this manner.
And good morning, Mr. Williams. Can you hear everyone?
Yes, ma'am.
And Mr. Williams, you have the right to appear in person with your attorney. Today, are you giving up that right and agreeing to appear by audio-video conferencing?
Mr. Williams, do you
Yeah,
appearing on
go
a
ahead.
computer?
Hello? What's that?
You agree to appear on the computer, correct?
Yeah.
Are you doing that voluntarily?
Yeah.
Okay, and you have a disposition?
That's correct, Your Honor. Mr. Williams would be pleading guilty to a Class 5 felony, attempted second-degree burglary, with an agreement that would run concurrent with all his others. It is open sentencing. He was, I think, in Concord, so it is an aggravated range of 2 years. And I had not heard back from Ms. Morgan if we could proceed to immediate sentencing or not. That is our request.
Okay, Mr. Williams, I'm going to advise you of your rights. First, please tell me your full name.
Bishop Jeffrey Williams.
How old are you? How old are you?
25.
How far have you gone in school?
To high school.
Do you read, speak, and understand the English language?
Yes, ma'am.
Are you understanding me as I'm speaking to you today?
Yes, ma'am.
Are you thinking clearly?
Yes, ma'am.
Have you taken any prescription medicine?
No.
Are you under the influence of any street drugs, alcohol, or marijuana?
No.
Are you suffering from any mental or emotional condition that would make it difficult for you to understand what's taking place?
No.
Are you serving in the United States Armed Forces, or are you a veteran?
No.
This court's understanding of your disposition is that you will be pleading guilty to added count 3, criminal attempt to commit second-degree burglary. It's a Class 5 felony. The other counts will be dismissed. There's an agreement that any sentence imposed will run concurrent, meaning at the same time as your other sentences, and that you would pay restitution, but the length of the sentence is up to the court. Is that your understanding of the disposition?
Yes, ma'am.
Is that how you wish to proceed?
Yes, ma'am.
Have you discussed this with Mr. Weber?
Yes, ma'am.
Are you satisfied with his representation?
Yes.
The charge you're pleading guilty to says that on or about October 5th, 2020, by engaging in conduct constituting a substantial step for the commission of second-degree burglary, you unlawfully, feloniously, and knowingly attempted to break an entrance into, enter, or remain unlawfully after a lawful or unlawful entry in the building or occupied structure of Stacy Clark, located on North Broadway Street, with the intent to commit therein the crime of theft. To that count, what is your plea, guilty or not guilty?
Guilty.
Before I can accept the guilty plea, I have to make sure you understand all the rights and the effects of your guilty plea, and I've been provided with a Rule 11 advisement. Did Mr. Weber read it to you and answer any questions you had about it?
I think so, yeah.
And Mr. Weber, is that correct also as to the elements?
Yes, read both documents.
I'm going to go through those rights with you. You have the right to be represented by counsel at all stages of a criminal proceeding, not just today at a disposition, but any trial as well. If you're determined to be indigent, counsel is appointed to represent you at no cost to you. You have the right to a speedy and public jury trial. At that trial, you would be presumed innocent. The district attorney must prove your guilt by proving all the elements of the charge beyond a reasonable doubt to all 12 members of a jury, because any jury verdict must be unanimous. At trial, you would have various personal rights: the right to testify, the right not to testify, the right to make the choice whether to testify or not, the right to subpoena and call witnesses on your own behalf, to cross-examine and confront witnesses who testified against you, and you would have the right to appeal to a higher court if you were convicted at that trial. Do you understand those rights?
Yeah.
And do you understand when you plead guilty, you give up all those rights?
Yes, ma'am.
Now, before you could be found guilty, the people have to prove the elements of attempted burglary beyond a reasonable doubt. And I've received two documents. One sets forth the elements, sets forth the elements of criminal attempt, the other of second-degree burglary. And I also read the elements to